She got on the stand and it was awful. And I remember, because I was the one assigned to do the cross-examination, and Robin turned to me and said, "Destroy her," because she was so bad. She was so cold, uncaring, and it worked.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are robinfrazierclark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Welcome, friends and lovers of the law. Today we have with us John D. Hadden, Georgia lawyer. We are going to be talking about premises liability with John and his latest win in the Georgia Court of Appeals in a premises liability topic, and exactly what is a premises liability case. But first, let me tell you a little bit about John. John D. Hadden is the owner and founder of the Hadden Law Firm, an experienced trial and appellate lawyer. He is the author of 3 respected treatises on Georgia litigation practice: Green's Georgia Law of Evidence, Georgia Law of Torts, Trial Preparation and Practice, and Georgia Magistrate Court Handbook, all published by Thomson Reuters Westlaw. He is also author of the evidence chapter in the multi-volume national Thomson Reuters treatise, Handling Motor Vehicle Accident Cases, 2nd edition. John is the president of Atlanta Trial Lawyers Association, a member of the Atlanta Bar Association, where he is chair-elect of the litigation section, and a champion member of the Georgia Trial Lawyers Association, where he is chairman of the amicus curiae committee. We may talk about that a little bit too, John. He assists attorneys from around the state in matters before appellate courts on our GTLA amicus curiae committee. He also serves on the Board of Governors of the American Association for Justice New Lawyers Division and is past chair of the litigation committee of the State Bar of Georgia Young Lawyers Division. John graduated with honors from the University of Georgia School of Law in Athens, where he was a member of the Georgia Law Review. While in law school, John served as a clerk for the judges of the State Court of Cherokee County and worked in the office of the District Attorney for Rockdale County, prosecuting felony and misdemeanor criminal cases. John earned his bachelor's degree from Emory University. And in his free time, John is an avid private pilot and a scuba diver. Interesting fun fact. John, welcome to the show.
I kind of like bowling too.
And drones too, I think.
And drones, yeah.
So that may go with piloting.
Once this call is over, I'm probably going to go take my drone out over the lake.
Well, welcome, and we're glad you're here. First of all, let's talk to us a little bit about your career before we get into your most recent win in the Court of Appeals on a premises case. I want to go into a little bit of your background. Why'd you go to law school, and tell us a little bit about that.
Well, why did I go to law school? That's a loaded question. During college, at one point I thought I wanted to be a doctor, and then I realized I was not really good at math and all that stuff. My wife was a neuroscience major in college, and she's very good at all that. She decided not to go to law school, to med school either, but I decided that my skills were better utilized, in the rhetorical and logical field, as opposed to doing science. So I think around junior year, I decided, maybe I'll go to law school. I took the LSAT and did fairly well. And
the rest is history, as they say.
Yeah, my stepdad's a lawyer, and he was always encouraging me to do that. And so I said, let's see what I can do. And so I got into Georgia, I got into Emory, and did not go to Emory. Sorry, Robin.
So, John, this is Lestertate. Robin left me out today, so I'm just going to That's okay. No
I was
problem.
reading from the script.
I know.
And my co-host Lestertate is with us also, obviously.
So, do you only do appeals now? And I'll tell you what intrigues me. I kind of hung a shingle when I was about 31, and been doing this longer than I was old. It seems at this point, and so I'm seeing a lot more younger lawyers that are like trying to specialize in one little area of the law. And when I started out, I might be trying a divorce case on Tuesday, and a personal injury case on Friday, and a criminal case on Monday, and that kind of thing.
No, I do not only do appeals. I love trying cases. I've tried a case with Robin, which we might talk about later, but I literally love picking a jury and arguing to the jury and all of that. But I would say about probably 40 to 50% of my caseload now is appeals.
That's great. And so, which do you think you like better?
I like them both. It's hard to say. I won't say appeals are easier because they can be a lot more stressful. When I'm having to,
but you don't have to worry about your witness showing up,
right.
And you don't have to worry about knowing what the jury's thinking, because you've got some idea, at least what the constraints are with a panel of judges. That they, what cases they're looking at and that kind of thing.
Well, I will say appeals are much less stressful from the standpoint of nobody's going to second guess me. Like, nobody's going to say, oh, you should have called this witness, or, you should have put in this piece of evidence. It's hard to commit malpractice on an appeal because the record is the record, and, we argue it the best we can. But still, I really do like arguing cases, trying cases. There's nothing quite like being in front of the jury, picking the jury, and then being in front of the jury and presenting the case for your client. And I love that.
And I think as you go along too, like a lot of folks, like we had Mike Terry on, and Mike's doing almost all, appeals now, and I do almost all trials. But, I've still argued about 30 cases in the Court of Appeals, or Supreme Court or the 11th Circuit. And so, you kind of go back and forth. And I think it's probably a good thing.
Yeah. And that brings up a good point. I'm not the most experienced lawyer out there. I've been practicing for 15, 16 years. But Mike Terry, as you mentioned, he and I have talked all the time on the phone. Like, we have questions for each other and we're asking each other for advice. So even fairly experienced lawyers are always asking other people for advice, like when I call Mike or Mike calls me. And, I can name a lot of other attorneys who I call, and we call each other back and forth. Charlie Court, for example, is outstanding appellate attorney. And we talk on the phone all the time when we've got, we're trying to bat back and forth various appellate issues.
Well, John, one thing I looked up was, and I don't remember the number now, I didn't write it down, but how many times do you think you've appeared in an appellate court?
I think it's probably somewhere around 70 or 80 times.
Okay. All right. And if the other 50% of your practice is all personal injury, is that right?
For the most part, I occasionally handle a one-off case on something else. I got a good result recently from the Court of Appeals in a probate case. There was a interesting case. My co-counsel who hired me to handle the case was actually the father of my opposing counsel in another case, the Ritchie case, Glenn Moffitt and Matt Moffitt. So what I really like about Georgia practice is everybody's really friendly. I'm helping out Glenn Moffitt in a big appeal, and I'm opposing son Matt Moffitt in another big appeal.
Matt's another one who's been a guest on our our nascent podcast adventure here. So
and I just love that because and I even talked with Matt, and I'm like, I'm helping your dad out on this appeal, and he says, "Oh, that's awesome. Hope you win that one. Hope you lose ours."
So with the Ritchie case, I want to. I just want to lay a little groundwork because Robin's more familiar with the case. But one of the things with premises liability, and this, I certainly know it practicing law in a small town. Somebody comes in and they say, "I fell down at the Acme grocery store," and I don't think the lay public really understands what I think there are a lot of folks that think if you fall on somebody else's premises, like if I go over to visit with Robin and Bill Clark at their house and I fall, it's somehow Robin and Bill Clark's fault, regardless. And when you go to law school, they try to teach you differently. And then when you get out and start practicing and you represent some of those folks, you really learn the hard way that the establishing the liability on the part of the landowner or the land occupier is just not the same. So can you tell our folks just a little bit about what you have to prove in order to recover from an insurance company that's insured somebody's property or premises?
Yeah, well, I mean, premises cases, there's sort of, I don't know if it came from Seinfeld or what, but there's this sort of sense that premises cases are really easy. That is the exact opposite of the reality in Georgia. It is very, very, very hard to win a premises case in Georgia. There's the two-prong test. You have to show that the premises owner had knowledge of the hazardous condition, and you have to show that the victim did not have knowledge of it. And that doesn't necessarily seem so hard in principle, but it's really hard. I mean, just looking at a slip and fall at a Kroger or Walmart or Target or wherever, I mean, you've got to be able to show that the hazardous condition, maybe somebody spilled some water on the floor, whatever. You've got to be able to show that that was there for a certain period of time, long enough that that Target or whoever would have known about it, and that the victim did not know about it. And as the decisions have come out, they've really raised the bar on that. It's pretty tough to prove. Well,
would you agree? Would you agree that there was a time, maybe when I was closer to your age, when premises liability was such in Georgia that it had almost become sort of a word game between the defense lawyer and your client? And they'd come take your client, they'd say, take their deposition, they'd have them under oath, they'd say, well, what'd you fall in? Well, I fell in water. Well, could you see the water on the floor? Just sort of not, could you see the water before you fell, or did you see the water after you fell, or when did you see the water? But did you see that water on the floor? Yeah, I saw that water on the floor. And then the next thing you know, you've got a motion for summary judgment and you're about to get kicked out of court because you swore under oath that you fell in the water, sort of broadly, even though you didn't see the water before you fell.
Yeah, I mean, the cases are kind of all over the map on this. There are cases where the trial court has thrown out a case because the plaintiff could not say what he or she fell on. Like, the plaintiff would say, oh, I slipped on something. It was some wet substance, but I don't know if it was water or oil or vinegar or whatever. And the trial courts have thrown that out. Thankfully, the Court of Appeals generally has reversed those and said, you just have to show that there's some foreign substance on the ground, not that it was a specific, you don't have to describe the molecular structure of whatever you slipped on.
The other thing about those cases is that it's kind of like a sliding scale. So the more you prove that the Kroger owner or the premises owner knows that there's this bad condition on their floor, the more evidence you have of that and that it was so obvious to them, why didn't they fix it? The worse you're making it for your own case, because if it's so obvious they should have fixed it, would have been obvious to your client as well.
And Robin, you've got a case with Kroger right now, right? With some leaking something or other.
Just wrap that one up. That was in district court, and we resolved that. Thank goodness.
Yeah.
A difficult case, but yeah. And in that case, for example, it was we allege my client slipped on a piece of cellophane, or that bubble wrap that they wrap around drinks. We had video. We had hundreds of hours of video, but we had video about an hour before her fall of a vendor, taking off that bubble wrap, and it was everywhere. Then she comes along and slips on it. And then the Kroger manager put that bubble wrap cellophane in her pocket. So we had a spoliation motion, which I don't know if we want to get into that, but
no. If you want to, you can. But
we tried that. I focused on that part of the case, the covering up of evidence rather than the actual defect in the premises.
But I'm sorry, Lester.
Yeah, I was just going to say, so premises stuff is also pretty broad. I mean, one of the biggest cases I ever had was a premises liability case that involved a shooting. And so things with shootings and crimes and things like that are frequently part of premises liability. And so maybe you could sort of articulate for our listeners, because to me it's sort of the opposite in the common mind. There are a lot of people that think just because you slip and fall in somebody else's place, the owners and occupiers are liable. And then there's a similar popular view that's equally wrong, that, well, if some wrongdoer attacks you on somebody else's premises, where the owner is responsible for the security and whatnot of the place, that it's the wrongdoer's fault and the owner has no responsibility whatsoever.
Yeah, well, that's actually a good segue into what I was just about to say, which is that, the slip and fall type premises case, even though it may seem a universe away from negligent security shooting case, it's the same law that applies. Knowledge of the dangerous condition and lack of knowledge on the part of the plaintiff. So in my Ritchie case that I worked on with Pete Law and Mike Moran and Denise over there, our client was doing some work. He was a subcontractor for Kroger and was cleaning up the backside of the property, the belt line. And he saw somebody, or actually he didn't necessarily see it, but his coworker saw somebody breaking into his truck, both of their trucks actually. And the coworker said, "Hey, somebody's getting into our trucks." So they ran to the trucks, and my guy goes up to his own truck and tries to open the door, and he gets shot and killed. And that's sort of, it's kind of the same thing as any other premises case. There was a dangerous condition. I mean, this was at the Kroger on Ponce, which is sort of known as being a dangerous place. There's a
may or may not be a nickname for that Kroger, as I recall.
I'm not going to mention the nickname, but I told Robin she could. He did not. The second prong of that test was the big problem in our case, which was because, our guy saw somebody in his truck and ran toward the truck. So did he assume the risk? Kroger's own representative said, "We don't think he did anything wrong. We would have done the same thing." The coworker said, "Yeah, I ran toward it. We saw somebody hanging out on our trucks, and so we ran to see what was going on." But Kroger's official legal position was, "Oh, he assumed the risk because he saw that there was a criminal in his truck and ran toward it. And we said, look, that's totally reasonable. You don't assume the risk that you're going to get murdered just because somebody's in your truck. Any reasonable person would run up to your truck and see what's going on.
I tried, when I was reading the case, I tried to put myself in your client's shoes, which is always good exercise. And I tried to think, what would I do? Would I have run? I mean, the case doesn't say that he ever saw this man armed or he just thought, I don't know what he thought, but it didn't show a gun.
Correct.
So I was trying to think, would I run to my car? I don't know. I don't know what I would do, but I can understand. I can understand it, what he did.
I agree. I mean, I don't know what I would have done personally, but honestly, if I saw somebody in my car, I frankly probably would have run to the car.
Yeah, I can definitely understand it. So the burden of proof for a plaintiff is the same in a premises case involving a shooting, like in the Ritchie case, as it is in a slip and fall at Kroger on a piece of cellophane.
Right.
Is that right?
Yep.
Tell us
and and I was going to say, I give a lot of credit to the trial judge in the Ritchie case, Judge Taylor, who at the oral argument, he said, this is a really close question. He said, I was not involved at the trial stage. I just got brought in for the appeal, but he told Pete, he said, Pete, I think you need to appeal this because I think the Court of Appeals needs to figure this out.
So that means at the trial stage, Judge Taylor granted Kroger's motion for summary judgment. Is that right? Right. Case over, and you have to appeal to the Georgia Court of Appeals.
Correct.
Just to kind of explain it for our listeners. And now we know that the Court of Appeals ruled in your client's favor. And what's going on now? Is somebody going to apply for cert or,
No. We're just waiting for the remediature right now, where the Court of Appeals sends the case back down to the trial court. Neither Kroger nor the security company that was the other defendant has sought reconsideration, nor have they filed for cert. So you'll
Pete and Mike will be trying this case at some point whenever we start back jury trials, I guess.
Right.
Whenever that is.
Yeah. And I've called Matt just to talk to him about it, and they just don't seem to be interested.
Let me ask you about that the Ritchie case. How do you go about proving that this place had a lot of prior crime and that Kroger was on notice of problems?
Well, the nice thing in the Ritchie case is that they essentially admitted that. I mean, this was, again, there's a certain nickname for that particular property. But in a typical case, and I've handled a number of premises cases, negligent security cases, generally what we do is we will get the matrix of the neighborhood that will show all the crimes for, the past 3 years or, some certain period of time. And usually we'll have an expert talking about how prevalent crime is in the area. So, we have experts generally to testify to that. Although I had a case a while back where we did not have we did have an expert, but we didn't have him testify, but we just put in his affidavit that showed the matrix of the neighborhood that showed that crime was just pervasive in the neighborhood.
You don't have to call to be able to prove prior crimes. You don't have to call the prior victims and have a parade of witnesses come in and testify. I was also shot at the Kroger or something like that.
Well, it depends on the procedural posture. If you're on summary judgment, I think we can make it through with just affidavits. And in the Ritchie case, they didn't really dispute that they knew that this particular Kroger was, had a lot of crime. One of my earlier cases, which unfortunately we lost, involved underground, and they didn't really argue, that they didn't have knowledge either. I mean, they more or less acknowledged that crime was pervasive at underground Atlanta. And we had all the evidence. We had the matrix showing the whole neighborhood and all the crimes that had been committed. We lost for a different reason, but I mean, I think that ideally, in a perfect world, you might want to have a witness to testify, but when you're on summary judgment, you can work off of affidavits.
The Ritchie opinion, which was authored by presiding Judge Miller, also goes into the right for any reason. I guess defense attorneys argued, hey, give us a break. We may not have used the right arguments, but the result was right. And we have an old doctrine in Georgia law called right for any reason, meaning that if the right result was reached, even though we argued it differently in the court below, the court should just affirm. Can you talk a little bit about that? And my question to you is, should we get rid of that right for any reason?
And Robin and I have talked about this over the past few years, and I mean, I understand the rationale for that rule, because it's a judicial economy rule. If the trial court was right, but they just got the reasoning wrong, then why should we send it back down and just let the trial court waste their time reissuing a decision based on what the Court of Appeals says? This all comes back sort of to preserving error, but it's kind of the opposite, because the defendant or the appellant always has to preserve error and make the right arguments at the Court of Appeals. And this is sort of the opposite of that, saying, well, if the appellee did not raise these arguments, it doesn't matter if they didn't raise the right arguments. I will say, and I do not like this rule.
I don't either.
I will say that I have seen in the past couple of years, I think the Court of Appeals has been kind of cutting back on this.
Let me push back on that for just a minute, because, and one of the things for our listeners, one of the things that we have, a summary judgments where the case gets kicked out without having a trial because the court says there's not any dispute as to the facts and the law favors one side or the other just as a matter of law. And on those, John, typically the standard of review that a court looks at, an appellate court looks at what the trial court did, can be anything, and a lot of different cases. Some things it may be abuse of discretion, but for summary judgment, the standard of review is de novo review. And so you're going into the appellate court really with a clean slate, and by de novo review, you don't have to you don't have to necessarily show an error below. You just get a re-argument of the thing with whatever was in the record below. And so is the right for any reason rule also sort of rooted in that notion that, you got de novo review. So if you got de novo review, even if there are other reasons, you can bring them to us because we're starting from ground zero. We're not just looking at that opinion like we might do on something that excludes evidence or whatever, where the standard review is abuse of discretion.
The problem that I have is, I get brought into a lot of appeals after it's been argued at the trial court, and the trial lawyers have not necessarily argued what they should have. And so I'm stuck with what I've got to argue. So you have to, if we're stuck with what anything they want to, that's the problem I've got.
Yeah, it seems to me it contravenes all of our rules about following the record. It's got to be in the record, or we can't hear it. It kind of is a sandbag trick by the defense that they can raise something on appeal for the first time because we haven't even talked about it.
Right. Yeah, and again, I will say that I think that based on some recent decisions I've read, I think the Court of Appeals is sort of backing away from affirming cases based under that rule. They tend to be vacating decisions for further consideration.
All right. Since we're talking about premises liability and your win in Ritchie, there was another case that just recently came out in March of this year, right when our coronavirus was starting, Star Residential versus Hernandez. And in that case, another shooting at an apartment complex, I believe. But I wanted to talk a little bit about it because it was the Court of Appeals addressing whether the Street Gang Terrorism and Prevention Act could be applied to a premises owner in a civil premises liability case. And the Court of Appeals held, yes, it can be. So is that going to be something that premises liability plaintiffs' attorneys are going to be asserting more often in crime cases?
I think they will. I think they and we will be. I will say I have some reservations about that personally. And there was, and I can't remember the name of the case, but there has been some authority that has questioned whether, that law is constitutional in other contexts. It does trouble me a little bit as a plaintiff's lawyer, trying to associate or try to bring in other, general association. I mean, it's basically character evidence. And under Rule 404B, generally that doesn't come in, but the way that the Supreme Court and Court of Appeals have ruled on that, they generally do allow in that sort of evidence. And as a plaintiff's lawyer, or if I were still a prosecutor, that would be great, but it does bother me a little bit that you're basically bringing in character evidence.
Yeah. Well, the Court of Appeals seemed to, they went, really, it was I guess to look at the text of the statute. And when they read the exact wording of the statute, they concluded, well, yeah, it does apply. That this is apparently what the legislature meant, that a private individual who's injured in a premises, if they can show that it's harboring gang activity, knew about gang activity, they can bring a cause of action, have treble damages. Which, when you think about it from the legislature's standpoint, bringing that kind of civil liability action would encourage premises owners to kick off their premises gang members. So, I mean, it has a good policy behind it.
No, it's going to be helpful for me in my cases. I just have some sort of civil liberties issues with it.
Would it have applied in the Ritchie case?
No, I don't think so. I mean, as far as we know, these guys were operating independently.
Okay. And then I know that you are on the Ritchie case. You're working with Pete Law and Mike Moran, and then in just a few days ago, there was an article about another case Pete has that was on a motion for new trial that Mike Terry, one of our friends, argued for Pete and Mike on a premises liability case, a shooting case that the client had been paralyzed in a crime at a Kroger, and it was a $70 million verdict. And Judge Purdom in DeKalb State essentially upheld it, remitted it a little bit, but upheld the verdict. And I was wondering if you could comment on that.
Well, I'm familiar with that case from the standpoint of we were he had that case when we were working on the Ritchie case. I don't know the exact details, but it was a pretty similar case to the Ritchie case. Mm-hmm. In that case, the The victim survived, but was obviously seriously injured. And I think that Judge Purdom entered a remediature based on something about future medical expenses, but he upheld almost all of it.
Yeah.
But it was a similar situation. In fact, I think we may have reused some of that evidence in the Ritchie case, as far as, Kroger's knowledge of, and I don't remember this exactly, but Kroger's knowledge of, crime generally in the Atlanta area.
Okay. You mentioned earlier a case that you and I tried together. It's been a long time, I know, but I wanted to mention that because that was a interesting case, a declaratory judgment action that went to a jury trial. And can you talk a little bit about what a declaratory judgment action is? Because not a lot of trial lawyers who try cases all the time, not many trial lawyers have tried a deck action. And I just recently had a case, I just recently resolved a case where I had a wrongful death case in state court, but in federal court, the insurance company filed a deck action. And those lawyers kept telling me, oh, this is a motion. The judge is going to decide this on a motion. And I kept saying, no, she's not. This is a jury question. We're going read my lips. We are going to be striking a jury and have a jury decide this issue. And they just couldn't quite understand that you could have a jury trial in a deck action. So tell us a little bit about that.
Yeah, like Rob and I started my career as a defense lawyer, and we filed deck actions all the time. But I may have tried one of them. I really can't remember. But the case that Robin is talking about was a horrible situation. There was a relatively young couple. They were in their early 40s up in Gwinnett County, and they were hit head on by a guy driving a 2001 Camaro, I think.
Wow.
And both people in the Camaro were killed, the driver and the passenger, who was Robin's client's daughter. And then my clients were the guy who was, or the parents of the guy who was killed in the other car, and the passenger who survived. He was the only survivor out of the four. Horrible case. And I drove up to the yard and saw the vehicles, and it was just really a terrible scene. But we settled the case with the underlying insurance. And it was a decent amount of
State Farm.
Yeah, it was, and they had decent insurance. It was like $250, $500, I think.
Oh, State Farm was the excess. That's right.
Well, they were both.
Okay, both. Okay.
They I think they had $250, $500, $250 per person, $500 per wreck, and they readily gave that money to us. And I had sent a letter to Tom Harper, good friend of mine, great guy, and said, "Hey, Tom, we'll settle this, but we need proof that this is the extent of the insurance." And he was like, "Oh yeah. State Farm tells me that's all there is." I remember very clearly. I was dropping this was pre-e-filing days. I dropped the releases in the mail. And when I got back up to my office, I had a voicemail from Tom Harper. He said, "Hey, John, you had asked about an umbrella policy, and turns out there was one. We don't think it applies, but I wanted to make you aware of it." So that's how Robin and I ended up trying a case together.
And the issue, as I remember it, was whether this young man who was at fault in causing the wreck was a resident of his parents' home at the time of the wreck. Because if he was, there was $1 million in coverage. If he wasn't, there was no more.
Right.
And I recall the verdict forms was simply, it was this young man a resident, yes or no?
Yeah, I mean, that was really the whole question. They brought in, so it was Tom Harper, then he quit working for State Farm. Then Blair Craig.
Oh, okay. I was going to say Hilliard Castilla.
Yeah, Blair Craig took over and filed the motion for summary judgment, which we won. And then Hilliard ended up trying it with us. And offline, I can tell you some funny stories about Hilliard and Robin, but I'll
He's a great trial lawyer.
He's a great trial lawyer, but man, that was some of the funniest things I've ever seen. But yeah, the whole thing came down to, I will never forget this. And Robin, you may not remember this. You remember when we were planning for this trial, we had said, we've got to treat the mother with kid gloves.
I remember that, yeah.
Because we thought that the jury was going to just find her very, very sympathetic, and we did not want to antagonize her and make the jury think that we were attacking the mother of the kid who was killed, the at-fault driver. She got on the stand, and it was awful. And I remember, because I was the one assigned to do the cross-examination, and Robin turned to me and said, "Destroy her," because she was so bad. She was so cold, uncaring, and it worked because she was just. I will just never forget Robin turning to me, and I'm like, "Robin, what do I need to do?" You're like, "Destroy her."
One of the great things about a courtroom is you just never know exactly what's going to happen, in a courtroom.
You may have to change your strategy like that in an instant.
Yeah, absolutely. Absolutely. May end up changing your strategy. I told somebody the other day that I was once waiting for a jury, and I represented, it was a land case. I represented a defendant, and somebody else represented a co-defendant. And the jury was out, and the co-defendant came over and started talking about this group that he sang with, and there's nobody in the courtroom except us and the bailiffs. And suddenly he breaks into song and sings "Under the Boardwalk" for us there in the courtroom that day. And I thought, I've seen it all now.
Well, my absolute favorite closing argument ever was Robin's closing in that DJ case. Steve Thornton and I bought that transcript because we were like, Robin just knocked it out of the park.
Oh, you're sweet to say that. I do remember talking about singing, I sang in that, I sang "Papa Was a Rolling Stone," wherever he laid his hat was his home, because we were saying this guy's home was his parents' home.
Yeah.
It was fun. And it was good victory.
I should give credit to Steve Thornton
yes.
in that case, who I brought him into the case, and he, like a week before the trial, got Wells Fargo's corporate rep under subpoena, and we deposed her and brought up that last check that showed this kid wrote, 5 hours before the whole incident, wrote as his address his parents' address.
Yeah.
Which kind of cemented it for us.
Yes, great trial, and as I recall, Judge Adams, we were in DeKalb Superior. Great. I've tried a couple cases in front of him. He is an outstanding judge.
He's an interesting judge, but also an outstanding judge.
Interesting and outstanding. John, one last thing we wanted to ask you, as we ask all of our guests, what is your notion of justice, or how would you define justice?
So my dad is a minister, and so I grew up, with him talking about, fairness, and I don't know that he used the word justice, but that was kind of the idea. And then my stepdad is a judge, then a lawyer. And so I just really think of justice as general fairness. I grew up watching courtroom, arraignments, things like that in my stepdad's courtroom. And I just thought that, there was just sort of a general notion of fairness and trying to be nice to people. And if somebody did something wrong, fix it and make sure they know that it's wrong. But it's definitely not a, trying to necessarily punish people, but just trying to make sure that they know what's right. That's probably a terrible answer. But.
Sounds good to me. Thanks, John.
Does indeed. Thank you, John.
Lester?
Yes.
Do you have something that has happened in the news that you'd like to share with our listeners?
I absolutely do, and it's unfolding even as we speak and record this podcast today. But I don't think we've actually talked about it here. But as you know, with coronavirus and COVID-19 spreading and sort of running wild throughout in different states and different cities, you're having different responses. And in particular, one of the questions is, should a government be able to order somebody to wear a mask if they're out in public, or is conditioned upon them entering public buildings and whatnot? In some places, it doesn't seem to be too controversial. The Chief Justice of the Georgia Supreme Court has said, if you go in a courthouse, wear a mask. But one of the things that's happened here in Georgia is that Governor Kemp has said that he has the authority to order or not order a person to wear a mask pursuant to his emergency powers. And Mayor Keisha Lance Bottoms, who's the mayor of Atlanta, Georgia's largest city, has put in place an ordinance that requires people to wear a mask in public. And so Governor Kemp has gone to court and asked for a temporary restraining order against the city of Atlanta, the city councilman, and Mayor Bottoms on this part of the ordinance that says you're required to wear a mask if you're in the city of Atlanta. I think there are two things that are very important about that. One, there's not been a resolution to it. It's still pending. There were several judges that recused for one reason or another. In fact, the day that we're recording this. But ultimately, I think there are two things that are probably very interesting for our readers or for our listeners. The first thing is that, it's not just individuals against corporations or individuals against one another that go to court to try to solve these kinds of disputes. And when you have something like COVID-19, where there's a federal response typically to things like this, there's a state response, there's a city response for each municipality. And so there's frequently a question over who actually has the authority to do this kind of thing. We hear the President of the United States sometimes saying, well, all the schools are going to be open. The president probably doesn't have the authority to say all the schools are going to be open. The school board is the one that has the authority to say that, even though the president, whoever that may be, is at the top of the food chain, and the school boards are not at the top of the political food chain, at least. The second thing that I found very interesting about this case is that the governor actually asked that Mayor Bottoms and the council members be enjoined, that is, have a court order saying you can't even talk about coronavirus and you can't even talk about wearing a mask. And that is unusual from a legal perspective, if not unheard of. If you go to places like England that do not have a First Amendment, then courts will frequently enjoin somebody from saying something or from providing some kind of information. Courts in the United States typically don't have that authority, except maybe in criminal cases during the pendency of the case, but not beyond that. It's called the doctrine of prior restraint, and the U.S. Supreme Court said in New York Times versus Sullivan that the remedy is to sue people that say false things, not to stop them from having that right to free speech. So it will be very interesting to see what happens on this. I don't have a prediction about who actually has the authority. I'm not talking about whether you should wear a mask. I think you should to protect others if you go out. But I'm talking about who has the authority to impose or not impose that part of it. But it's going to be very interesting to see what happens on this free speech claim. And my bet is I'd put my money on the mayor on that one, just because we actually have a First Amendment and a lot of countries don't. And you'd probably get a different result if you were in some other countries.
I'm with you. I put my money on that issue on the prior restraint or the speaking about coronavirus with the mayor and with anyone. I mean, I think I believe even today that the CEO of DeKalb County is going to issue a mask requirement law. Michael Thurman. We'll see if the governor sues him. The governor hasn't sued any other mayor in the state of Georgia.
Hardy Davis and Augusta put one of those in effect. There's a difference under Georgia law. And today we've kind of been talking about a lot of technicalities about slip and fall and that kind of, there's a huge difference between cities and counties under Georgia law and how they're treated. And you could possibly even end up with getting one result, with the governor versus the city of Atlanta, and another result in the governor versus DeKalb County, if that ever came to be.
You could, and then there's an issue that I am wondering about because the city of Atlanta is in both DeKalb and Fulton, but he brought a case in Fulton County and not in DeKalb. Now, can a Fulton County judge order something for the citizens of DeKalb? That'll be interesting. But it also strikes me on the First Amendment question that this lawsuit was brought on behalf of the governor by the Attorney General of the state of Georgia or his assistant AGs. And what went through those lawyers' minds when they added that claim to a lawsuit? I understand trying to enjoin something, but not speech, not freedom of speech. And I think the First Amendment rights maybe are in jeopardy and may get trampled on, and we're hoping the judge does the right thing on that. But my money would be with the mayor on that issue as well. It'll be fun to watch. I was going to watch the hearing today before the recusal, and then I found out. So whenever they do have a hearing, I'll be watching because I think it'll be fun.
Well, it'll also be interesting. I'm going to be interested to see, and maybe we can talk about this later as we see how it falls out. But, if you want a temporary restraining order, you have to go into court and you have to prove your case before you get to a jury or you get to a lot of other arguments. You have to go prove your case. And, a lot of people file suits that ask for that, but then they don't ever proceed with it. And I'm going to be interested to see if the governor's office really and truly wants to move forward with the whole claim, and particularly the claim as it relates to freedom of speech.
It'll be interesting.
So what about you? What have you got for us today?
I wanted just to mention, I know it's on everybody's mind and heart, but the death of John Lewis, his passing. He was my congressman. I've lived in his district, the 5th district, for, almost 30 years. I didn't know him personally. I had met him once, actually in my church. He came and gave a sermon in my church. And he was a hero to me. He's a hero to my family. And I regret his passing. I know it's inevitable at some point, but he's the kind of man you wish could just live forever.
Well, I think he's a great reminder of, I think of a hymn that was in the Baptist hymnal, and it was actually from a poem by James Russell Lowell that says, "New occasions teach new duties, and time makes ancient good uncouth." And so if you go look at what people thought about what John Lewis was doing back when he was coming off the Edmund Pettus Bridge and getting his head beat in, a lot of people thought that he was an agitator. A lot of people had bad things to say about him. And he's a hero, and he's somebody who's actually affected change. And he's made what people were saying was good, which never was good, segregated life in America. He's part of the reason it's viewed as uncouth today.
And, I was talking to my law clerk, Austin Weatherly, who happens to be with us today, but talking to him about the fact that Mr. Congressman Lewis was not a lawyer, but may have affected more change in the law than anyone you could think of, which I think is very important. Two things that you mentioned, the Edmund Pettus Bridge, we all know his famous march to Montgomery. I'd like to see that bridge renamed in honor of Congressman Lewis, number one. And number two, I'm hoping our state government will permit his body to lie in state in the state capitol. I haven't heard anything about that. I know we've done it for other senators and congressmen who have passed. We did it for Paul Coverdale, I remember. So I'd like to see that. I don't know I haven't heard anything about if that's a possibility, but I certainly think he deserves it.
Well, and another possibility too is in the United States Capitol and Statutory Hall, each state has two statues of an individual from that state, and one of those now is the statue of Alexander Stephens, who was Vice President of the Confederacy, and there has been some move afoot to maybe replace that with a statue of John Lewis.
I would definitely support that. So that's all I have. Anything else?
Nothing else. I guess until next time, we'll see you in court.
See you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robinfrazierclark and lestertate, until our next episode, we'll see you in court.